Hello everyone, welcome back to RR Legal Talks. We have two channels, RR Legal Talks and RR Corporates. Today we are discussing on section 33. This is an abridged prospectus, is a mandatory with an application form. Otherwise, the penalty is 50,000 rupees per default. So in this video, we break down section 33 of the Companies Act 2013, which governs the issuance of application forms for securities. So learn when an abridged prospectus is mandatory and the exceptions and the legal consequences for non-compliance. So we'll discuss the key compliance tips for promoters, directors, and professionals, and exceptions to abridged prospectus, penalty provisions under section 33, subsection 3, and role of ROC and SEBI in oversights. So what is section 33 about? Section 33 lays down the mandatory requirement that no form of application for the purchase of securities shall be issued unless it is accompanied by an abridged prospectus. So this ensures that investors have access to essential information before applying. Investors shall have access for the essential information before applying. So why an abridged prospectus is essential? So the abridged prospectus is a condensed version of a full prospectus containing financial and risk factors, capital structure, terms of the issue. So it is prescribed by SEBI ICDR regulations and must be attached with every application form issued to the public. There are certain exceptions to this rule. You are not required to attach an abridged prospectus. The form is issued to a bona fide underwriting agreement. These securities are not offered to the public, that is private placement of rights issue. However, proper documentation must exist to prove that exception applies. So right to full prospectus. Even when an abridged prospectus is given, any person can request the full prospectus. So the company is legally bound to provide before closing the subscription list or the offer. This promotes transparency and informed decision making. What about the penalty? Section 33, subsection 3. If the company failed to comply with the above provisions, penalty 50,000 rupees per default. There is no separate penalty on officers, but multiple violations can result multiple penalties. So the provision is in force since 1st April 2014. So what is the practical compliance checklist? Ensure every application form issued to the public has an abridged prospectus. Clearly define whether the offer is public or private. Maintain records for underwriting invitations, if applicable. Respond promptly to request for the full prospectus. Coordinate with RTA and legal team during public issue management. Non-compliance with section 33 may seem minor, but the financial and reputational damage can be significant. Make sure your forms speak as clearly as your prospectus does. Like this video, drop your queries in the comments and subscribe for more corporate law insights that protect your business. We have two channels, RR Corporates and RR Legal Talks. Please do subscribe both the channels, RR Corporates and RR Legal Talks, for latest updates. Thank you.